calendars in order. I'm not aware of any judge who wants to chime in and take one of the cases. I know that's been the issue historically, is that Judge X has some cases on the calendar and offers up, hey, I'll take those cases. But the judge who's handling the calendar thinks, well, why don't I get all the other ones out of the way so I can be done and then you can have yours. And that makes life complicated for the folks at the facilities because they have queued everyone up in order of the calendar, which was published a long time ago. And so they've gotten prepared in the right way. So for today, at least, we'll go with the flow. With one possible caveat, it is my understanding that our supplemental calendar, one position, Travian Sheffield, is off now. That's a Judge Ellerby case, and it turns out she's going to handle one of these special hearing calendars next week, and Mr. Sheffield has been moved there. So unless someone knows otherwise, you don't need to have Mr. Sheffield in the queue. We will not be handling his case today. Judge Ellerby will handle it on whatever calendar she is managing in the coming week. Anyone have information different than that? Okay, so no Travian Sheffield, that goes away. And we are going to start with Adonis Andrews, who is an accountability court case. And why don't you tell me?
Hey, Judge McBurney, I'm sorry to cut you off, but we're going to do position 1 on the add-on as well, Mr. Kim on 5 South. I'm sorry, and then we'll jump to the regular calendar.
Oh, so you're going to have us go out of order this time?
No. If you check the chat, Judge, it's located in the chat. I'm sorry.
Let's see, chat. 4 North tells us we're going to do add-on. Whoa, and then some weird order. Why are we going? I spent all this time being lectured by someone saying you have to go in order, and this is not the order. I'm fine doing what you want, but why aren't we going in the order of the calendar?
Yeah, we was getting the add-ons out the way first, Judge. They were add-ons in order to the regular calendar.
Right. So that's
this so won't interfere with the jail operations. Just make it easier and smoother for the calendar.
Okay, but what about the 1, 5, 8, 2, 3, 4, 6, 7, 9?
We have officers in place at those areas now, and if we go off, it'll just disrupt the whole entire calendar and the jail operations. This way, it can go down smooth.
So we'll take that one offline. I'll follow your request here. I'm still confused as to why we have to do 5 before 2. And now I'm feeling a little frustrated that I got fussed at for taking things out of order. And now today we're taking things out of order. Maybe someone shouldn't have fussed. But we'll do Mr. Kim's first. I don't have any issue with that. And then for those folks on, I can't promise you any rhyme or reason to the regular calendar. It looks like we're bouncing all over it. So folks will need to be nimble. But we're going to start with Mr. Kim's. That's a plea. So we will need Mr. Forte dialed in for this one. The reason why I was wanting to start with number 1 on the calendar was just to find out if that was something that needed to be taken down. I can't quite tell what we're doing with a few of the accountability court cases, but we'll work through those in whatever order we're being told to take them when we get there. But we're going to start with Mr. Kim's. I see Mr. Franklin is ready, and there's Ms. Hall. Good morning to both of you. Mr. Forte, get the thumbs up. You're good. All right, and Mr. Kim's, is that you at 5 South? Okay.
Yes, sir.
Let's get on the record. This is 20 SC 174292. It's State versus LaFabian Kim's. Mr. Kim's, you are with us today because Mr. Franklin has indicated that he and you are ready to go forward with a plea. Is that correct?
Yes, sir.
All right. Well, when you answer questions, and most of the questions will come from Ms. Hall, who you can see on the screen, but some of them will come from me. make sure that you answer verbally. You're welcome to nod or shake your head, but you also got to say something, because our court reporter will take down only the things you say. So if the answer is yes, say yes. You can also nod your head if you want. But you were speaking up loud and clear. That's great. Mr. Kims, I need to make sure that you are waiving your right to have your lawyer physically present with you, meaning by your side, for this plea. Are you waiving that right?
Yes, sir.
Do you understand, Mr. Kims, that if at any point during your plea, you need to have a private, confidential conversation with Mr. Franklin, we can make that happen. You and Mr. Franklin, the feed from your camera and Mr. Franklin's will be redirected to a private space that I cannot see or hear, that Ms. Hall, the prosecutor, cannot see or hear, and the court reporter won't be able to see or hear it either. So the two of you can, if necessary, have a private conference. Do you understand that?
Yes, sir.
If you need it, let me know. I know Mr. Franklin will let me know, but if you need it, raise your hand, do something, and then there is a behind the scenes operator who will get you two into that private room, okay?
Okay.
The other thing, Mr. Kims, I need to make clear you're waiving is your right to be here in court. You have a right to have your attorney by your side. You also have a right to be here in open court where I'm sitting. It's an empty room, and you have a right to be here, but I assume you're waiving that right and you would prefer to go forward even though you're sitting there on 5 South. Is that true?
Right.
Okay. Then we're gonna do that. Let me find your case file. We've got it. Oh.
Good morning, Mr. Kims.
Hey, how you doing?
Good to see you.
All right, since yours is an add-on, I don't have the original indictment, so hopefully Ms. Vortis can email me a PDF of the indictment. I'll print it out, and ultimately I'll need to sign your name to it, but we'll talk about that if we get through the entire plea. Mr. Kims, in just a moment, Ms. Hall is going to swear you in.
Hey, good morning.
Like you were in court.
Hey, how you doing?
Cheryl was over there too. And then she disappeared. So that's the one we got set. And so she's on here. Wonder why she didn't tell us, hey, you morons, you're on the wrong.
Hey, there you go. Okay.
Oh my God.
Primovic, you need to mute. Thank you. Back to you, Mr. Kims. Ms. Hall is going to swear you in just a moment. Once you're under oath, it's important that you answer all of her questions and mine truthfully and completely. Will you do that?
Yes.
Also important that if you have any questions of your own, you let us know so that Mr. Franklin or I can answer those questions. You'll let us know?
Yes, sir.
All right, Ms. Hall, when you're ready.
Thank you. Mr. Kims, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes.
You may lower your hand. Please state your true, correct, and legal name.
LaFabian LaShawn Kims.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
I'm not taking no medication since I've been here. No medication since I've been here.
Is there any medication that you normally take when you're not in here? Okay. How old are you and how far have you gone in school?
I'm 41 and I went to the 12th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? Aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
Oh, no, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
I wait.
Do you waive any and all defects on the indictment, including with respect to the defendant's name?
Yes, if any, for purposes of this plea.
And do you waive moving forward on a copy of the indictment?
Yes, ma'am.
Mr. Kims, have you been arrested on these charges?
Yes, ma'am. Well, I turned myself in.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any additional warrants that are related to these charges?
No, ma'am.
No, ma'am.
Has your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes.
The minimum and maximum for aggravated assault with a deadly weapon is 1 to 20 years to serve. The minimum and maximum for possession of a firearm during the commission of a felony is 5 years to serve, to run consecutive to any other count. And the minimum and maximum for possession of a firearm by a convicted felon is 1 to 5 years to serve. Do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence for aggravated assault with a deadly weapon, 5 years to serve 2 years, balance on probation. For possession of a firearm during the commission of a felony, 5 years suspended. And for possession of a firearm by a convicted felon, five years to serve 2, balance on probation. But the court does not have to accept that recommendation. The court can sentence you to the maximum on each of these charges and can run those sentences consecutively or one after another. Do you understand?
Yes, ma'am.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to have subpoenas, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the charges of aggravated assault with a deadly weapon, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon in indictment number 20 SC 292.
I'm guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, freely.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, had this case proceeded to trial, the state would have proven that on December the 8th, 2019, at 2075 Allison Court, Southwest Atlanta, Georgia, officers were dispatched to that location in reference to a shooting. When they arrived on scene, they were informed that the defendant was a suspect who reached into the store, opened the store door, reached into the store and shot a firearm. That gun did strike a victim, Mr. Robert Tanner, Tanner, in the arm. Witnesses on scene was able to positively identify the defendant as the person who shot the gun into the store by a photo lineup after officers did an investigation and was able to locate the vehicle that the defendant left in and get identification that way, Your Honor. And also, the defendant has 2 prior felony convictions. One, entering automobile conviction out of Fulton County, SC number 13 SC 120893, disposition date of October the 30th, 2013, and a possession of cocaine charge out of Fulton County, SC number 01 SC 07068, disposition date of August the 14th, 2001. That is all from the state, Your Honor.
And tell me again, please, Ms. Hall, your recommendation.
For the aggravated assault and the possession of a firearm by a convicted felon, they're both 5 to serve 2, balance on probation, and possession during the commission, 5 years suspended.
Okay, and has your office been in touch with Mr. Tanner?
Yes, Your Honor.
He's aware of this recommendation?
Yes, Your Honor.
He doesn't require any restitution for any medical attention he received for getting shot in the arm?
No, not at this time, Your Honor. He is going through our victim program to have those medical services reimbursed to him. As of right now, he hasn't received any medical bills yet, but he is handling all that through our victim program.
Okay.
But I did have a very long conversation with him multiple times about this is why the recommendation is, under the circumstances, what it is, based on my conversation with the victim and a little bit of the defendant's history being a little older, and just constant conversation with defense counsel about this case. But I did have an extensive conversation with the victim about the recommendation. It even went down after the conversation.
Does Mr. Tanner know Mr. Kim's?
No, not at all.
And the address at Allison Court is it's a convenience store?
It is. It's a gas station, and Mr. Tanner was at the ATM of the so when you enter the store, there's an ATM to the right. He was standing at the ATM getting money out the ATM.
Were you ever able to develop a theory for why this happened? It's a strange crime. It's a dangerous one, but it's a strange one. If Mr. Kim's doesn't know Mr. Tanner, then he shot a stranger. It doesn't sound like, because there's no charge here, you didn't add in your factual basis, that he then zoomed in and took Mr. Tanner's money. It's a guy sticking his gun in the store and pulling the trigger, which is is odd.
I agree, Your Honor, and I also thought it was odd. So I kept the conversation with the victim was multiple times. Do you know if you've seen him in passing? Was there some kind of conflict that you were not aware of? You know, since I was only privy to talk to the victim, but I haven't been able to come up with a theory other than it was a random act, just done for no reason, is what I can gather, with the victim telling me he does not know this person. Even after being showed a photo, he still doesn't ever recognize him from anywhere.
Okay. Thank you.
You're welcome.
Officer Calhoun, I see you on the call. Are you serving as the primary DCS source of information, or are you here because there are some accountability court cases and I should be asking someone else for criminal history?
I think I'm handling everything today, Your Honor.
All right, jack of all trades. Do you have any other Georgia criminal history for Mr. Kim's beyond the 2 convictions Ms. Hall mentioned?
No, Your Honor.
Is the entering auto case, I don't know how it could still be open. He can't be on active probation right now.
That's correct, Your Honor. I do not show that he's on active supervision.
Okay, got it. Mr. Franklin.
Thank you very much, Your Honor, and good morning. So essentially, what we have is Mr. Kim's, as he stated already, is 41 years old and has a limited criminal history. Certainly nothing that rises to the level of the allegations here. We have reviewed the discovery, and upon my evaluation, there are some additional things that are problematic for us in relation to the IDing of Mr. Kim's. Not problematic to the extent that it's something we should challenge necessarily, but that kind of give teeth to the state's allegations and have motivated us to engage in conversations for the solution. Particularly one of the facts being that his sister is one of the persons who identified him through a photograph that was provided. Upon learning that he was a suspect in this case, Mr. Kim stepped forward and took accountability and turned himself in. He didn't have to be hunted down. He didn't have to be sought out on a warrant. He heard he was involved, submitted himself to authorities. He's been in custody about 123 days. That includes the period of time from arrest to us pleading right now, and indictment and such. And under the circumstances, I would say this is a pretty speedy resolution. I think we probably got into it quicker than they would probably get to a lot of cases in the non-complex. And I owe that much to Mr. Kim stepping up and taking accountability for his actions. This is a negotiated agreement, and that's where I leave my argument. We just ask that you accept the plea as negotiated.
Okay. Mr. Kim's, do you know this Tanner gentleman that we're talking about?
Well, I never told my lawyer, but yeah, I know the guy from being, he moved over there to Allison Court, but he shot at me. That's the reason why I shot at him.
He shot at you that same time or at an earlier
no,
time?
Yes, it was earlier time. I just never knew his name at the time. You know what I'm saying? But I never called the police and put him on police with, told the police about him. But yeah, when I called him and I seen him again, that's when I did what I had to do.
Okay, so just so I'm following this, it wasn't that 10 minutes before you shot him, he shot at you, but there was an incident in your life where you believe, I wasn't there, Mr. Tanner shot at you. And so the explanation or the answer to the question I asked Ms. Hall, like, why would this happen? It's sort of an odd, it wasn't a robbery, it wasn't this, is because you were, I'll use the term, retaliating for what you believe he did to you.
Well, I know he did it to me. He was right there when the situation happened, you know what I'm saying? But at the time, I had sat back and I went and got me a job for about a couple of years. And then when I came back over there, he was still with the unnecessary. So I had just went on and handled my business because of fear of my life. You know what I'm saying?
Did Mr. Tanner, when he shot at you, did it hit you?
Yeah, it hit me on the bottom.
Okay.
Yeah, right in the bottom.
Do you know why it was he shot at you?
I guess because he's a drug dealer, you know what I'm saying? He's over there trying to, he's a bigger guy than me. So he's trying to pick on me as a resort of everything, you know what I'm saying? Trying to chump me off, make me look like a little boy, You know what I'm saying? He came at me the wrong way, so that's the reason why me and him had a problem.
Okay. How tall are you?
I am 5'6".
Okay. And he's taller.
Yeah, and he recently just got out of prison. You know, I don't know how many years ago, but yeah, ever since he got out of prison, he's been with the unnecessary. You know what I'm saying? I've been on Addison Court all my life, and he moved over there, I guess, with his little girlfriend and everything, and he's been just trying to really bully me.
So would you be going back to Allison Court when you finish your sentence?
No, I'm not going back. My girl just got an apartment over in Washington Road in College Park. And as soon as I get out, I'm gonna find me another job, and I'm not going back over there, period.
I think that's a great decision. Okay. Have you and Mr. Tanner had any communication since December 8th when this happened?
No, because he don't really, you know, I really never know his name, and everybody over there never really knew the guy, you know what I'm saying, until he started hanging out at the store. But I got
you guys
his name.
recognize each other, but it's
yeah,
not
I recognize him because every time I get on the bus, you know, I might go over there and buy me something. And I know a couple people over there every now and then.
Yep.
And when I seen him, I just went on and react.
Okay. Ms. Hall, do we know how severe the injury was? I think you said he was hitting the arm. Did his arm have to be amputated? Was it stitches? What do you know, if anything, about the nature of Mr. Tanner's injury?
Yes, Your Honor. So he had to have surgery on his arm. There was a rod placed into his femur bone. He said he had to get a rod placed there. He said, but now, other than the rod being there, everything is functioning as usual. There's no extra pain or any of that. The recovery wasn't that long, but there is a rod in his arm now.
Okay. But it's his arm. You said femur, which is your thigh bone. It wasn't.
That's what he said. That's why I hesitated before I said it, but that's what he told me. He definitely did know that it was his arm and he broke some type of bone. I think he just chose the wrong word.
Got it. Okay. All right. Mr. Kims, I find there's a factual basis for your plea. You are bracingly direct about what happened and why it happened, and I appreciate you not beating around the bush. It sounds like life at Allison Court can get complicated at times.
Yes.
I think you get it that while by your code you did what you needed to do, that's not okay. And the reason why folks are upset in part is because Mr. Tanner got hurt, but doing what you did, bullets aren't remote control, and you could have missed, you could have hit something, and then someone who had nothing to do with your beef with Mr. Tanner could have gotten hit. And that's just not okay. It's just too often, not quite daily, but it feels like it's daily that we read about folks getting killed by stray bullets. And layer on top of that the fact you shouldn't have been walking around with a gun in the first place. This is a problem, but I appreciate that you are not ducking this. You're not making excuses. You're very matter of fact. He did it to me, so I did it to him. That's how the game is played. So there is a factual basis for your plea. I also find that your plea is knowing and voluntary. Knowing means that you've understood all the things we've been talking about. Is that correct?
Yes, sir.
Any questions about anything?
Am I going to get credit for time served?
You will get credit for all 123 days, however long it is. The day you turned yourself in is the day your clock started ticking, and you'll get credit for all that. I also find that your plea is voluntary. That means no one is forcing you to enter this plea, and that the only promise that has been made to you is the state's recommendation. Is that correct?
Yes, sir.
Okay. Then I'm going to accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. And what that means, Mr. Kims, is that when you are on probation, if you have a small or technical violation, you don't have to come back in front of me. let's say, and I'm making this up, let's say you test positive for marijuana. It may be that probation says you got to get some drug treatment or do this or that. And that's not going to get you back in front of me. What will get you back in front of me is if you get in trouble with the law again. So if you stay out of trouble, you're working, you're staying with your girlfriend, all that kind of stuff, then you and I won't be bumping into each other unless I go to where you work or you happen to be in court for some other reason. That's how POM works. I will follow the joint recommendation. I think if you had been anything less than as candid as you were, I wouldn't have, but you are not making any excuses for what happened. It was a real dangerous thing you did. I'm guessing you don't have a rod in your butt. This guy has a rod in his arm. There's a school of thought that says he deserved it because of what he did to you. But the way we ought to be doing things is you don't get to be the vigilante and say, I'm going to equalize things. But you'll have another year plus to be thinking through all that. So on count one, and count three, I will sentence you to 5 years to serve 2 years with the balance probated. And count two has to run consecutive by law. But I will suspend those 5 years. So it's a total sentence of 10 years to serve 2. You'll get credit for the time you've served, but you got some time still to serve, and you will get shipped off to DOC. They've begun moving people out of the jail. They started on Monday. You're going to be pretty far back in the line because you were sentenced only today. But in the next few weeks, you will get shipped down the road where you will stay until the Department of Corrections determines you should be paroled. Then you'll be on probation. You need to understand those 5 years suspended. They're not invisible. You won't be supervised. You won't have to report to probation. But if you were to get sideways with Mr. Tanner again, the state could file a motion to have those suspended years revoked, just like you can have your probation revoked. So you actually have 8 years that you're going to need to do your best to not shoot at people and stay out of trouble. Because I'll tell you, if we are back together in court because you did anything with a gun, you looked at a gun, you held a gun, you polished a gun, I'll revoke some of that time. You and guns are taking a break now. You got to deal with baseball bats or something else, but you're not allowed to have guns, okay?
Yes, sir.
You also can have no contact with Mr. Tanner. I think you're going to not have a problem with that, but you leave him alone. If you see him for some reason, you turn around and walk away. You don't figure out another way to try to put a hole in him. And I'm going to have you stay away from Allison Court. So you may still have friends or family there. They can come to you in College Park. But if you get arrested in the Allison Court neighborhood, that's going to be a problem that you're going to have to work through with me, all right?
Yes, sir.
Any questions with any of that?
No, sir.
Ms. Hall, any other conditions you want to see for his probation?
No, Your Honor.
Mr. Franklin, anything else for Mr. Kims?
No, sir.
So, Mr. Kims, you, if we were together in court today, would have signed your indictment indicating that you're pleading guilty. Do you authorize me to sign on your behalf?
Yes, sir.
Mr. Franklin, you authorize me to sign on your behalf?
Yes, sir.
And Ms. Hall?
Yes, sir. Yes, Judge.
So Mr. Kims has already waived any issue with us proceeding with a copy of the indictment. I will print out the copy that Ms. Fortis has emailed to me when we're done with this calendar, and I will sign all 3 names to the indictment indicating that Mr. Kims has entered a guilty plea and he has been sentenced as I just set forth. Anything else, Ms. Hall?
Nothing from the state, Your Honor.
Mr. Franklin?
No, sir.
All right. See you, Mr. Kims.
Your Honor.
Yes, Mr. Calhoun, Officer Calhoun.
Yes, he needs to be given instructions to report to the Department of Community Supervision within 72 hours of his release from custody, and failure to do so will result in a warrant being requested for his arrest.
Good point. Forgot about that. Had you been here in court, a probation officer would have met with you, Mr. Kims, before you went back into lockup. It will be your job to report to probation within 72 hours of being released by the Department of Corrections. So you may serve your full 2 years, you may serve less if you're paroled, but as soon as you are released by the Department of Corrections, you've got 3 days, 72 hours to make it to the folks at probation to say, here I am, here's my home address, here's how you can find me, tell me who my probation officer is. Do you understand that?
Yes, sir.
Do you know where you need to go?
No, sir.
How do we get that information to him, Officer Calhoun?
Your Honor, that's an excellent question. I can verbally give it to him online.
Yeah, no, I know you could tell him right now. I could tell him it's on Memorial Drive, but I'm not going to expect Mr. Kims to have memorized that address for 2 years.
Yes.
Mr. Franklin, how have you been working through this for your
Write it
colleagues?
down.
The place to report, Mr. Kims, is across from pretrial. So you know what?
Pre-trial?
Across from city pretrial.
Pre-trial, okay.
Yeah, exactly. The old pretrial building. Yes, across from.
Okay.
That Memorial and where Peachtree turns into Whitehall.
Yeah. Okay. You can write it down. You don't mind. Hey, do y'all have the address? So I got the officer who here with me. He want to write the address down for me.
That address.
Fantastic. Thank you, mystery officer.
Yes, that address is 276 Memorial Drive, Southwest, Atlanta, 30303.
276 Memorial Drive, Southwest, ATL 30303.
Thank you, Judge.
You bet. All right. No more shooting, Mr. Kims.
I won't.
All right. Thank you, everyone. According to our list, we will shift now to Adonis Andrews. But I can do a different way if it's someone else, because it says 7 North, and I have Adonis.
This is Andrews right here. This is Andrews
right here, 7 North.
Okay, it says 2 North here, but that's fine. All right. So, Mr. Andrews, that's you with the red coolers in the background?
Yes, sir.
Okay, great. Before we start taking this down, tell me, Ms. Primovic, what we're doing today with Mr. Andrews.
Good morning, sir. He is going, excuse me, he is going to go back to BHTC, Your Honor.
Okay.
He's a track 1 and they are taking him back. I think Mr.
So,
Tucker
Mr.
is on
Forte,
this call.
you can stand down, Mr. Forte, for this conversation. All right, so tell me, Ms. Primovic, what's going on with Mr. Andrews, and we'll make a plan.
Yes, Your Honor. Mr. Jonathan Tucker. Oh, there we go. We have some. Okay, go ahead. They are taking him back, Your Honor.
So yes,
that's
Judge,
all I'm concerned about.
Most of the BHTC cases today are just the first appearance to let them know what's going on. So he got picked up on our warrant from leaving his housing, and so he's been picked up. We're finding him housing. We'll get him out, continue on, put him on an ankle monitor, and he'll continue the program.
Mr. Andrews, did you ever start with BHTC, or we lost track of you before you could even start?
Yes, sir. I started in everything, and I reported to Mr. Tucker and them. I had some things going on with my family, but I talked to my family since then, since I've been incarcerated. I've been incarcerated for a month. And so they kind of told me the plan of me getting released and I'm going to get housing. So I'm kind of well aware of everything that's going on right now. That's all. And about the ankle monitor and things.
Okay. Mr. Tucker, we are providing housing for Mr. Andrews, or his family is?
We are providing housing. Last I spoke, he couldn't return to his mom, so we're getting housing for him.
Okay, so when BHTC staff comes to collect Mr. Andrews, they'll have an ankle monitor and they'll have transportation to get Mr. Andrews to Hope Hall and or to his residence.
Yes, sir, that's correct.
Fantastic. Any sense of when that would be, just ballpark?
Hopefully within the next week or so. The housing we use has been backed up, so hopefully within the next week or so we can get him going.
Okay, Mr. Andrews, you understand that as soon as the BHTC team can ensure that a bed has opened up for you, they'll come get you, The ankle monitor will get put on so we can find you faster if you decide to go elsewhere. And then they'll get you to your housing. You understand that?
Yes, sir.
Any questions about anything?
No, sir. I don't think so.
So I just want to caution you, I will not be the judge working with you. It'll be Judge Reader. But I do want to caution you that we don't do too many AWOLs. So if things start happening in your life that get complicated, instead of disappearing on us, reach out to someone on the BHTC team so that we can see if we can help you. We're here to help. The goal is to get you through the program so that you've got a new and improved set of coping skills to help you not only with addiction, but with behavioral health issues. But of course, we cannot help you if we can't find you. So if you're starting to feel stress and worry, reach out to the team to see if we can help you, because we're not going to run after you too many more times. You understand?
Yes, sir, I understand.
Okay, Ms. Sellers, anything you want to add from the DA side?
No, Your Honor.
Ms. Primovic, anything else on behalf of your client?
No, Your Honor. Thank you for asking.
Great. All right.
Take care,
so
sir.
Mr. Tucker, it sounds like Mr. Andrews has heard what he needs to hear, and he'll just be anxiously awaiting the big white van to show up.
Absolutely. Yes, sir.
Okay. Thank you. Thank you, Mr. Andrews.
Thank you.
All right. Next should be number 5, Funziel Woods.
Hello.
Hello, Mr. Woods.
Hello.
And Ms. Primovic, same situation. We are
Absolutely
welcoming.
Yes, Your Honor.
Why don't you get us started then?
Your Honor, this is Mr. Woods. He has talked to Mr. Tucker and people to be in BHTC. He's assigned to Judge Reader, and they have graciously accepted him to return back to the program, do what he's supposed to do, ask for help when he's supposed to ask for help, and participate fully. So we're very happy that Mr. Woods gets another opportunity for the BHTC program.
Thank you so much.
Well, you're welcome, Mr. Woods, although we're obviously worried about you because we had to track you down. Your case is a little older. It's a 2017 indictment. How long ago did you start BHTC?
As soon as I got out, I started BHTC. So about like 2018.
Okay. And then you went away for a while?
Yes, I found out I was HIV positive. When I got here, thank God, I found out I was a false positive. So that's why I ran away. But it's really no excuse. I should have stayed in the program and used my resources to help guide me through the situation instead of running, because I have a great clinician and a great caseworker. So I really had no excuse of leaving the program without finding and seeking help. So
who's your clinician?
Miss Lee.
And who's your caseworker?
Mr. Williams.
Well, you got great folks. Yeah, rely on them. Don't run from them.
Yes,
but that's also some heavy news that you got. So
Yes,
there's obviously understanding on our part. But you need to understand, this is now reverse direction understanding, that we need to be focusing our time not on trying to track people down, but on treating them. So in the future, if stressors arrive in your life, do your best to turn to the team for support, because we're not going to give you a whole bunch of more chances to.
Oh no, this
run
is
from
it.
us.
I'm not gonna jeopardize that.
It's complicated times right now. You obviously can't get as much FaceTime with clinicians and case management and whatnot. But if you work the program, it will help. And we've got a good set of resources. Judge Reader is going to be real helpful as well. So we do welcome you back. Mr. Tucker, there he is. Will Mr. Woods be wearing an ankle monitor?
Yes, sir, that's correct. And Mr. Woods, do you have housing? Where were you staying last? Do you have viable housing?
Yes, sir.
Okay,
But I was also looking into want to go to SLA if possible, but I do have housing already.
Okay, we'll have to get that address from you.
Okay.
What is it?
It's 799 Chestnut Place Northwest, Atlanta, Georgia 30314.
And who is this with?
Sir,
Who is this with?
it's a friend. It's a time also like I'm in.
What's the phone number of the friend?
I don't have the phone number, but
Okay.
this is where I was staying previously.
Okay. All right. We'll look at RPH housing for you as well.
Okay.
Can you give, what's the name of the person who is the owner or occupant of the address?
So what's that?
What's the name of your friend who occupies this address?
It's my ex-boyfriend. His name is
Yeah, that's not good. We'll find you housing.
Okay. But no, I remember his name. Hold on.
I'm not putting you on the spot. I'm just trying to get a little information.
Yeah, no. It's been a minute since I've seen him.
Why do you think it would be okay for you to go back there?
Because I was staying there previously before, and it's also close to BHCC, so it's very helpful for me to be able to transfer.
No, I know it's good for you, but why do you think that your ex will let you come back?
Oh, because I talk to him on Facebook all the time, and he's telling me to come back home.
Okay. You're able to do Facebook from the jail?
No, not here, when I was out.
Okay, how long have you been in jail?
About a month now, I think.
Were you, so you were in BHTC, and when you were in BHTC, you were staying with your ex.
Yes,
when
sir.
you left BHTC, you were no longer staying with your ex.
Yes, sir.
Okay, but you believe that you can go back there at least temporarily?
Yes, sir.
Okay, all right. I'm gonna let Mr. Tucker take it from there, but at least we've got the address. You will have an ankle monitor on. It's important that you stay in contact with us so we can keep tabs on what's happening, okay?
Definitely, yes, sir.
All right, Ms. Sellers, anything on Mr. Woods' case?
Your Honor, just to remind the defendant that his case is a first offender, so not completing the program has significant ramifications for that sentence.
Okay. Right, that's an important point, Mr. Woods. Not that you don't have enough on your shoulders already, but your charges effectively go away if you successfully complete your sentence.
Yes,
and that
sir.
means getting through BHTC.
I will.
If you get terminated from BHTC, it could be, not necessarily, but it could be that you lose your first offender status and then you got a felony, and that just makes life even more complicated.
Yes, sir. I won't let that happen. I will not let anything jeopardize me completing this program. It's a great program. It really saved my life, and it helped me in a lot of ways with my mental health. So it's really a great program. So it's no excuse for me to have ran in the first place.
All right. Well, Judge Reeder looks forward to working with you, and more importantly, the staff does. And it sounds like if you already have a place, Mr. Tucker, would Mr. Woods get picked up sooner than the previous gentleman?
Yes, sir. We'll have that investigators verified, and then he'll go from there.
All right. As soon as we can verify the residence you'll be going to, then they'll come get you, Mr. Woods.
Yes, sir. Thank you so much. Thank you, everybody. Thank you so much for sending me back to the program, and thank you, Judge.
You bet.
You can do it.
I can, and I will. Thank you.
Yeah, you can. Excellent.
All right. Next is Dante Baylor.
Judge McBurney, it sounds like they're pulling him out of the zone now.
Okay, I'm happy to do it in a different order. I'm just following what 4 North told us.
Yeah, he's on his way out now.
Okay. Mr. Franklin, this is your case. Is this a negotiated plea?
No, sir, it's non-negotiated.
Okay. Is this before or after Mr. Baylor had a final plea date?
Before, I believe.
Before.
Okay.
Don't quote me 100%. I don't recall going to a final plea.
Hey, Howard, that's you on 4 South.
Coleman, they pulling him out of the zone now.
Okay, cool.
And again, sheriff's people, I'm happy to take someone different. I was told 8 was next.
Well, I have Miss Grant here if you want to do her.
Yeah, I got him here, Judge. I'm sorry.
Okay, go ahead, Judge. He's there now.
Okay, no worries. Let me get his case file 310. Hello, Mr. Baylor.
Good morning.
Good morning. I'm Judge McBurney. How are things on 4 South?
It's a little okay, a little hectic. It's been crazy here.
No doubt, no doubt. Mr. Baylor, this is a time when you, as I understand it, are going to attempt to enter a guilty plea in your case. Is that correct?
Yes, sir.
Okay, and you've had an opportunity to discuss your situation with Mr. Franklin?
Yes, sir.
Okay, well, we're going to get on the record then. Mr. Forte's ready. This is position 8 on our calendar. It's 19 SC 172-310, State versus Dante Baylor. We have Ms. Hall for the state, Mr. Franklin for Mr. Baylor. Mr. Baylor, you are appearing remotely. You are at the jail. I'm here in court. Do you waive your right, Mr. Baylor, to be here physically in court for your plea?
Yes, sir.
Mr. Baylor, you also have a right to have Mr. Franklin by your side so that you can confer with him if you have questions or concerns during the course of your plea conversation that you're going to have. Do you waive your right to have Mr. Franklin by your side?
Yes, sir.
You're waiving it, but I'm happy to tell you that it's not a complete waiver in the sense that if you need to talk to Mr. Franklin, if something comes up where you're confused or concerned and you want to have a private, confidential conversation with Mr. Franklin, we can make that happen. Do you see all the little squares on the screen?
Yes, sir.
All right, so there's one that says FC trial calendar. And the person who is hiding behind that tile is able to move you and Mr. Franklin into a private conference room. So if there comes a time when you need to talk to Mr. Franklin where no one else can see or hear it, let me know. And FC trial calendar will move the two of you into that room, okay?
Yes, sir.
All right, then we're gonna move forward. Ms. Hall is gonna put you under oath in just a moment. Once you are under oath, it's important that you answer her questions and mine truthfully and completely. That means if you have your own questions because you don't understand what someone said or you're confused or something, you need to let me know that you've got a question and Mr. Franklin or I will try to answer it. Okay?
Yes, sir.
All right, Ms. Hall.
Thank you, Your Honor. Mr. Baylor, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You may lower your hand. Can you please state your true, correct, and legal name?
Dante Lee Baylor.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 36 years old and the last grade I completed was 11, but I just got my GED here in the jail at the New Beginnings program.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses: aggravated battery, aggravated assault, and possession of a knife during the commission of a felony?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to those charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
I waive.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, if any, for purposes of this plea only.
Mr. Baylor, have your attorney advised you of the minimum and maximum sentence to the charges that you're pleading to?
Yes, ma'am.
The minimum maximum sentence for aggravated battery and aggravated assault is 1 to 20 years to serve. The minimum maximum for possession of a knife during the commission of a felony is 5 years to serve, consecutive to any other count. Oh, I'm sorry. Do you understand if your guilty plea is a blind plea, also called a non-negotiated plea, the state will still make a recommendation to the court?
Yes, ma'am.
Have you discussed this offer with your attorney?
Yes, ma'am.
The state's offer is for aggravated battery and aggravated assault, 10 years to serve 3 years, balance on probation. And for the possession of a knife during the commission of a felony, 5 years suspended. Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes, ma'am.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would? And this is true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction? As a result of this guilty plea conviction, just as there would be following a trial. For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or use a firearm, transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that if you went to trial, you will have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of charges after a trial?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
How do you plead to the charges of aggravated battery, aggravated assault, and possession of a knife during the commission of a felony in indictment number 19 SC 172310?
I plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Baylor. Your Honor, had this case proceeded to trial, the state would have proven that on October the 6th, 2019, at 2601 Charlestown Drive, College Park, Georgia, in Fulton County. Officers were dispatched to that location. Officers were dispatched to that location and identified the defendant as Mr. Dante Baylor. Officers were told that Mr. Baylor got into a verbal altercation that became physical with his boyfriend, whom he formerly lived with, being the victim Jamal Mills, Jamal Mills. The victim was stabbed by the defendant with a knife, with a blade in excess of 3 inches. The victim suffered a stab wound to the lung. He had a collapsed lung. The incident was reported to police by another roommate that lived with the victim, who called 911. He also informed the officers that he walked into the room and he saw the victim laying on the floor in a puddle of blood, and the defendant was standing over top of him. And when he said that he was going to call the 911, the defendant told that individual not to, because the victim would be okay. When the police arrived, no one on scene knew what happened, including the defendant. The defendant ended up riding to the emergency room with the victim. Later on, after speaking with the victim, officers were informed by the victim that the victim and the defendant got into an altercation. During that altercation, the victim realized that he was stabbed, and the officers took out a warrant, obviously, for Mr. Baylor. Mr. Baylor does have a prior conviction. It is an assault second degree out of Maryland. Disposition date of October the 22nd, 2005. That is all from the state, Your Honor.
Are you able to tell Ms. Hall if that 05 conviction from Maryland is a felony?
No, it wasn't a felony. It was a misdemeanor.
And I can't, Your Honor. I don't have the GCIC in front of me, so I don't know for sure. I would like to rely on the complaint room that it was when they added it to his felony convictions, but I can't say for sure.
Okay. All right. Officer Calhoun, do you have any criminal history for Mr. Baylor?
No, Your Honor. The Department of Community Supervision does not have a history for the defendant.
Okay. All right. Mr. Franklin? Oh, before you go, Mr. Franklin, I believe that count 2, the aggravated assault, the way it is alleged and based on the facts that you have proffered, Ms. Hall, is not a 1 to 20, but a 3 to 20. I think that it is subsection I of the aggravated assault statute. Family violence aggravated assault has a range of 3 to 20, not 1 to 20. That doesn't change your recommendation. Your recommendation falls within that. But Mr. Baylor, you need to understand that any sentence I give you for count 2, the aggravated assault, would start with a 3. It could be 3 years probation. It could be 3 years prison. But the lowest sentence you could get if you plead guilty to count 2 would be something that starts with a 3. The second thing I need to observe on the legal front is, because of that, I don't think counts 1 and 2 merge. My initial thought was these 2 counts merge, that the aggravated assault would merge into the aggravated battery. So there'd really only be a sentence on count 1, but I don't believe they merge, because there is the element of the relationship between Mr. Baylor and Mr. Mills that would have to be proven for count 2 that would block, if you will, the merger of 2 into 1. That may be more than folks wanted to hear, but I need to get that on the record. And more importantly, I need to make sure that Mr. Franklin agrees there's no merger. Do you agree?
I do, Your Honor. I had been prepared to make an argument for merger, but having heard the court's logic and quickly re-looked at the indictment, I do believe the court to be correct.
And Mr. Baylor, I need to make sure you understand that the sentencing range for the aggravated assault is 3 to 20, not 1 to 20. Do you understand that?
Yes, sir.
Does that change your willingness to go forward with the plea?
No, sir.
Okay, now, Mr. Franklin, your turn.
So I think it's important in these circumstances, Your Honor, to provide a bit of context of kind of exactly who we're dealing with. Mr. Baylor and Mr. Mills, the court hadn't been able to gather already, were involved in a relationship. And there was as best as we can gather, an altercation, a struggle of some kind from a relatively minor relationship argument. It escalated very quickly. One of the reasons that I believe it escalated as such is because of Mr. Baylor's condition. Mr. Baylor has a dual diagnosis. In terms of his mental health, he has bipolar 2 disorder, and he also suffers from anxiety. He paid Depakote, and I also believe he paid aside from that, if that weren't enough, he has a drug addiction. Prior to being arrested, he had been using crack cocaine, powder cocaine. I believe there was even some crystal meth usage, for things such as marijuana and alcohol, which we would, probably safely assume otherwise. Mr. Baylor, my understanding was that he had no prior felony convictions. In my discussions with them, I had been prepared. I'm asking for first offender, but I understand there may be some debate over that 2005 incident. What I will say in that regard, Your Honor, is that I don't have the ability to run an NCIC through my office's capability, so I had no way to verify that one way or another. And I'm certainly believe my client would not lie to me about it. He told me he had a misdemeanor and not a felony. What we are asking for of the court is a sentence that is rehabilitative more than punitive, because we believe a significant portion of punitive punishment has been inflicted. Mr. Baylor has been in custody about 226 days. And during that portion of time, Your Honor, we certainly have been dealing with the COVID epidemic within the jail. And for lack of a better comparison, I think a number of those days kind of have been served under dog ears, where one day kind of is more than an actual day given the circumstances. More importantly, however, what I believe is that we have made arrangements with a program where he's been interviewed and accepted. I believe the court is familiar with Hope House. It's one of the more structured and regimented programs that we have access to through our relationships with the Public Defender Office. They provide individual counseling, group therapy. For the first 60 days, there are limitations in terms of the person's ability to come and go. They have to get ID and those kind of things. One of the reasons that I believe Mr. Baylor is deserving of this consideration is that he has, in the time that he's been in custody, he's taken actions that he wasn't able to accomplish on his own while he was out on bond, while he was not arrested. One of those things, he has obtained his GED since he's been in custody. And he had not done that before. He had gone to a technical school or a trade school, and I believe he had gotten a certificate in computer information systems. Is that right, Mr. Baylor?
Yes, sir.
But he had not been able to actually receive the certificate because he hadn't gotten a GED before. So he kind of had some achievement that he wasn't able to utilize to his advantage. Additionally, one of the things that we initially was going to request of the court, but now it's kind of indefinite, he had been involved in the K-9 program at the jail. And I think that provided him a great deal of perspective going forward. We were going to ask that part of the sentence be that he complete the K-9 program, but he is still presently inside Fort South. I'm not sure when the K-9 stuff is going to kick back up. That's a bit too indefinite for me to make part of my request, but I wanted to put that out there for the court. And then after he completed the K-9 program, to have his sentence commuted into the Hope House program. So without the K-9 program, we would just simply be asking for a 5 to do 1, and for that 1 to be to the Hope House program. I believe, I've not been able to talk to Mr. Mills myself, but in my conversation with Ms. Hall, I do believe that Mr. Mills may be on board with a sentence that doesn't include prison time. But I haven't spoken to him myself, and I can't make that representation entirely flat-footed. But for those reasons, Your Honor, we're asking for a reduced sentence into a program with whatever conditions the court feels appropriate.
Hey, Judge McBurney. This is Nakia Roberts from pretrial.
Hello, Ms. Roberts.
Hi, I have an NCIC for this defendant, and I also showed the felony conviction out of Maryland in 2005.
Okay. Well, the way we're going to handle that is I'm going to treat it as a felony, but if Mr. Franklin is able to get documentation from Maryland, I mean, the information is out there. And NCICs are tricky to read. Not that Ms. Roberts is reading them incorrectly. I'm sure she's reading it correctly, but bad data in, bad data out. So if I can be shown that it ultimately was a misdemeanor disposition, I will amend the sentence to make it a first offender sentence. But today's sentence will not be first offender because I think there's too much of a cloud around how did the Maryland case play out. I appreciate it was 15 years ago, but the hard data, the NCIC, is saying felony. I heard Mr. Baylor really clearly say it was not a felony. We need to work that out, but that's fixable. So if Mr. Baylor goes forward with his plea today, the sentence will not be first offender. But if Mr. Franklin is able to get hands on a certified copy of a disposition that shows it ultimately, despite what the initial charge was, became a misdemeanor, I will amend the sentence so that it becomes a first offender sentence. Ms. Hall, is there restitution owed for medical bills for Mr. Mills?
Your Honor, the same, the victim in this case is also going through our victim program to have those medical bills repaid.
Okay. Have you, Ms. Hall, or has your team, Ms. Rolak, talked to Mr. Mills about the case and a possible disposition?
Yes, Your Honor, and the victim is on the phone with Ms. Rolak. He doesn't wish to speak. He's just listening in. But yes, I have spoken with him about the plea, the recommendation from the state and everything.
Okay, and I certainly won't require Mr. Mills to say anything. Are you comfortable sharing with me, Ms. Hall, what he has said to you about the state's recommendation?
Yes, sure. I told him that the recommendation would be prison time. He has had a relationship with Mr. Baylor for 5 years. So he says that he wants to continue to have a relationship with him. Maybe not a romantic relationship, but a friendship. And that for him, prison is a bit much. If it was his choice, it would be probation.
Okay. But of course, you're entitled as the prosecutor to come up with what you think is for the public, the right recommendation. So that gets to my next question. Mr. Mills would not want a no contact provision as one of the conditions. At some point, Mr. Baylor is going to be on probation, whether it's sooner or later, we'll hear in just a minute. But whenever he is on probation, Mr. Mills is not asking for a no contact.
That is correct, Your Honor.
Okay. So Mr. Baylor, you should try to keep your end muted until, I promise I'll hear from you, but there's a lot of stuff going on in the background. So if you could stay muted until I have questions for you, that'll help our court reporter. Thank you. All right, so you've talked to Mr. Mills. All right, now I do, after all that, I have a few questions for you, Mr. Baylor. So thank you for someone muting it now that has to be unmuted. So Mr. Baylor, Mr. Franklin mentioned that you've got a mental health diagnosis. Do you normally take medication for the bipolar diagnosis?
No, sir. I just recently started taking it, like really once I got here. I was on the regimen. Beforehand, I had tried to start it on the street, but I wasn't able to do it because of limited funds. Unable to get prescription for it. Mental health medication is kind of tricky to take, but I was able to take other medications.
So a doctor has prescribed medication in the past, but it was hard for you financially, logistically, to keep current on the prescription.
Yes, sir.
Okay, but now that you've been in custody for 200 plus days, again, you've been diagnosed in that way. And while at the county jail, you have received mental health medication.
Yes, sir.
Okay. And are you taking it right now?
Yes, sir.
Does taking the medication make it easier for you to understand what we're talking about, or does it make you woozy or confused?
It makes it easier. I completely understand. I'm more leveled out. I'm not manic and hyper and all over the place.
Okay. All right. And you agree with what we heard from Ms. Hall and Mr. Franklin. You and Mr. Mills have known each other and been in a relationship for a number of years. He's not someone new in your life.
No, sir. That's correct.
Okay. And the place that you shared on Charlestown Drive, you had a third roommate. I guess it would be a second roommate. There were three of you.
Yes, sir.
Okay. All right. Congratulations on getting your GED. That was a good step to take. Is there anything you want to tell me, Mr. Baylor, before I talk a little bit about what I think ought to happen?
Well, number one, I am apologetic for everything that happened. I never really realized that I really did have a problem as far as mental health. Like, people would make jokes and say things like, well, you do too much, you're all over the place. I never really seen it until the doctor actually showed me the symptoms of what it was. She showed me bipolar 1 and bipolar 2, and she told me to circle the things on which one I had, and I circled just about everything on bipolar 2. And then also I worry a lot, so I never understood that what that worrying was my anxiety. I can worry about the little teeniest things that would make me upset. Then another thing is I never really had that much belief in myself. Like, one of the things that I used to go back and forth with Mr. Mills is that he would try to push me to go forward with getting my education finished, and I just never could believe that I could do it. And since I've been here and I started the program and I actually did it, I was one of the, it was 2 of us that actually passed. It was about like 7 of us that went and 2 of us passed, and I passed everything the first time with flying colors for high scores. So that made me feel good. And then once I got a chance to talk with the people at Hope House, I think her name was Miss Hill, she let me know about the program. It's a very good program, seems to be very good. I could stay there for a year to 2 years to get myself together for drug treatment. I've been drinking since I've been about 14, 16. So like I had the conversation with her, for me not to have a drink in my life, but even this long it's a miracle. Also later on the drugs came into play that I'm trying to change around. So the program they got there is pretty structured. And like Mr. Franklin said, for the first 60 days, you don't go anywhere, you stay there. And then after that, for 30 days, the next 90 days, you're doing job readiness and they're getting you ready to go to the job and start you back to transition into the working world and into the living world. But at the same time, you still would stay at the program and still would be there taking like, you would be living there, taking classes daily, going to work, and you will also be making sure that you're not on any kind of drugs, alcohol, taking tests daily. So I'm asking for leniency from the court for a chance to really get myself back together, back to the way that I used to be. On that Maryland conviction, I am really kind of stoked with that because I know that at one point they were all felonies, but then the lawyer that I had got them dropped down to a misdemeanor charge. He said that I was going to take a misdemeanor charge. So I don't know, maybe that's why I was showing felony and it's not showing that it was dropped down to the actual misdemeanor, but that's what it was. And I absolutely would not lie about that because I don't think that I would have been able to get the jobs that I had in the past with an actual felony conviction on my background.
Okay. Well, like I said, that fact is discoverable. It's just hard to see what dispositions are in states outside of Georgia. So Mr. Franklin can sort that out. And if we can confirm what you're saying, then I will make your sentence a first offender sentence because that would be a legal sentence. But for now, the sentence that I'm going to impose in just a moment will not be first offender, but that's only because we're missing that proof. Well, Mr. Baylor, I find there's a factual basis for your plea. You and Mr. Mills got into it, and you took it to a level that you shouldn't have. The good news is Mr. Mills is alive and well now. But as I'm sure has crossed your mind on multiple occasions, that knife being a little bit this way or that way, and he's not with us anymore. It's not a little puddle of blood on the ground, it's a big puddle, and you cut the wrong thing, and there's no paramedic on the earth who can get there soon enough who would have been able to save his life. So there is reason to be concerned. I am impressed with what you've chosen to do with your time in custody. And I think that shows promise going forward. But I need to be mindful of the seriousness of what got you into jail. I also find that your plea is knowing and voluntary. Knowing means that you've understood all the things we've talked about, either right off the bat or because you asked a question and we answered it. Do you have any questions about anything we've discussed?
No, sir.
Okay. Voluntary means you're entering this plea of your own free will. No one's forcing you to do it. Is that true?
Yes, sir.
Okay. The sentence that I'm going to impose, Mr. Baylor, is pursuant to the Probation Options Management Act. And all that means is that when you are on probation, if you have a small problem on probation, let's say you miss an appointment, or you're supposed to be seeing a doctor, because that's going to be one of the conditions that I impose, is that you take all your prescribed medications, and you're not doing that. You're not going to have to come see me. You and probation will work through that. But if it's something more serious, you get in trouble with the law again, that's the kind of thing where you'd come back in front of a judge. So, Mr. Baylor, I find that I come down somewhere in between what the state is asking for, and I appreciate the sentence that Ms. Hall has recommended, given that this wasn't a cut on the hand or a cut to the calf, but a stab to the chest and a collapsed lung. I also understand where Mr. Franklin is coming from. He and his team worked very hard to emphasize the restorative with an eye to getting clients back on their feet and more productively involved with our community. And it sounds like you'd like to stay here in our community. What is the Maryland connection, by the way? Are you originally from Baltimore? What were you doing in Maryland in '05?
That's originally where I'm from. I'm born and raised in Baltimore, Maryland.
Okay. When did you come to Atlanta?
I came to Atlanta the first time in 2008 to like 2012. I got homesick. I went back home. But I came back down here because I had a better job option. I had got a job at UPS as a supervisor, but due to my addiction and the problems that I was having, I lost a job, which is something I'm working for to try to get back.
Sure. Well, the GED is going to help with that. And if you end up as a first offender, that'll certainly help too, because you don't have to check that dreaded box about being a felon. So Mr. Baylor, hear me out on the sentence, and then I'm going to give you and Mr. Franklin an opportunity to talk. We can move you to that conference room I mentioned, because you have the ability, if you want, if you think it's in your best interest, to say no to the sentence, if you think something would change between now and the next time we meet, or if instead you decide you want to go to trial. But I do think that a continued time in custody is appropriate. And what I'm going to do, let me get the sheet back out here. I'm going to sentence you on counts 1. Well, I have to do it a little bit differently because of the way count 2 works. So count 1, I guess I'll do it. Counts 1 and 2, your sentence is 5 years to serve 2 years with the balance probated. You'll get credit for all the time that you've been in. And count 3 has to be consecutive, and it has to be 5 years, but I will suspend that. So the big number is 10 years to serve 2 years. The one I think you're most focused on is the 2. So it's a little bit more than 1, which is what you've almost already done. But it is less than the 3 that the state has asked for. Then you'd be on probation for 3 years. And then there's that 5 years that has to run consecutive. But I'll suspend that, meaning you're not reporting to anyone, you're not under anyone's supervision, but there's this sentence out there if something bad in your life happened, meaning you got arrested, got in trouble while you're on that suspended sentence, theoretically, the state could come back here to say, we want to revoke some of those suspended years in the same way that you can have probation revoked. But of course, if you're a first offender and you are staying out of harm's way, that's all academic and not something that would get in the way. I would make as a special condition of your probation that you take all medications and follow all counseling programs as prescribed and recommended by the medical professionals in your life. So if you've got a doctor who says you need to take medication X, that's actually a condition of your probation that you take it to make sure that you are as stable as the medical profession can help you be, the way you are right now, where you knocked out your GED, you got involved with these good programs, et cetera. I will not say no contact with Mr. Mills. That was the first thing I wrote down until I heard more about your connection with him and his request that you stay connected with him in whatever way the two of you decide is the healthiest. So that's the sentence that I'm comfortable with and the one that I'd impose. It's different from what Mr. Franklin lobbied for. It's also different than what the prosecutor asked for. I want to give you a chance first to ask any questions if you have questions about what I've just said. And then second, if you want a chance to speak privately with Mr. Franklin about the pros and cons of going with the sentence and when you might be paroled and all that versus saying, no, thank you. And then your case would move towards a trial calendar of some sort whenever we are able to move on to having trials. So first, do you have any questions about the sentence that I have described, Mr. Baylor?
Does that mean I do county time or do I do prison time?
So it means two things. It means you've already done 213 days of your sentence. It also means that you would be subject to transport to the Department of Corrections. They've started moving people. Folks who were sentenced a month ago, 2 months ago, DOC has picked them up and moved them on. Mr. Franklin can answer in a more informed way than I can whether the sentence I've described is one where DOC would say, you've served so much of it already, we're going to leave you where you are and you'll finish up in the county, versus nope, they'll come pick you up. You may not be in the state system very long, but they would come pick you up. I don't know the mechanics of that other than to tell you, I do know that as of Monday, the state prison system has begun moving people into the system again. So we've had over 50 folks move from Rice Street to DOC custody over the course of this week, and that number will only grow. So that's not the best answer, but I shared with you what I know. Do you have other questions?
No, sir. I just want to speak to Mr. Franklin.
Okay. FC trial calendar, can you move Mr. Baylor and Mr. Franklin to a room? And when you all get there, when you're done, you have to move yourselves back. We can't come get you. So when you're done, you click return to main room or whatever the magic button is, okay?
Okay.
Eight. We could, if folks are ready, pivot to position 2. That's going to be a quick one. Does not need to be taken down. And I see, are you Mr. Darden?
Yes, sir. Yes,
so
Your
let's
Honor.
do that. And then when Mr. Franklin comes back, we will return to Mr. Baylor's situation. So Ms. Primovic, is this the same situation? We're welcoming Mr. Darden back to BHTC?
Yes, Your Honor. However, we had some orders. I'm trying to make sure, see my notes on Mr. Darden. He had, Mr. Darden had some hold issues that we worked on. he showed a hold in Rockdale County, but called there and it was released April 4th. However, Mr. Darden, as we talked about, you still have that warrant in Rockdale County for shoplifting that you have to go and take care of, okay? And Your Honor, BHTC is, the personnel is aware of that. He also has a hold in Douglas County. He missed a court date on March 11th of 2020. So, and unfortunately, he was not incarcerated in Fulton County because they was going to take a certificate of incarceration. So what we're asking to do, Your Honor, and I don't know if an order has been signed yet, I believe it may be presented, that he go to Douglas County, a signature bond to Douglas County, and then an accountability court hold will be placed on him once he gets there so that they can pick him up from there and release him to the proper, to his proper treatment here in Fulton. We tried really hard to get rid of that Douglas. Miss Sellers tried through her connections at Douglas County, but we just could not get them to release that hold.
And they're showing no holes on the jail screen.
Pardon me?
I don't show any holes on the jail screen.
Oh, okay. So maybe, okay. There were, so I don't know when that, maybe Miss Sellers, you did work your magic. I didn't think you were able to. So
why don't we do this? I have a few more things to say to Mr. Darden, but BHTC can try to come pick him up, or if he's being released because he's got housing. And if he is denied exit because the jail screen is not up to date, then we know the paperwork that needs to be executed, where it would be the signature bond followed by a hold that would get Mr. Darden to Douglas. The part I'm confused about is Rockdale. You said there's a warrant, but not a hold from Rockdale?
They released their hold, Your Honor. It was a shoplifting misdemeanor, and they didn't want to come and get him.
Okay.
But he needs to know that the warrant is still out there, and he needs to go to Rockdale to take care of it.
Got it. So if he got stopped by an officer, the officer might see the warrant in there, all the more reason to get to Rockdale to clear that up. But
Absolutely.
Your understanding as of this morning was that Douglas didn't lift anything and that Mr.
Right.
Darden was going to have to be transported to Douglas.
Absolutely.
Okay. Mr. Darden, did you start BHTC and then you left us, or have you never had a chance to start BHTC?
I think I started one day and that was it. I didn't show back up, sir. I'm sorry.
Where'd you go?
Cobb County. They had a hold on me. That's where I was in March.
You got arrested after day one?
Yes, yes.
How'd you get arrested?
Right here. Fulton arrested me. Sent me to Fulton arrested me. Cobb County put a hold on me after I got reinstated back to BHTC.
Okay.
Cobb County picked me up and I did 4.5 months over there with an 8-month sentence. That's where I was in March. I was not out. I never got out.
Okay. Well, that may be something that Cobb and Douglas can duke out. I don't know, but the part I'm here for is to welcome you back into BHTC, to encourage you to stay in BHTC, and it goes without saying, but I'm going to say it, to encourage you not to get new charges in Cobb or Rockdale or Douglas, because that'll yank you out of BHTC. And the one thing we can't do is help you if you're not there. So you got a lot of little things scattered around the metro Atlanta area, and we're trying to bring everything under one roof so we can get you the treatment that you want and that you need. But you got to cooperate with us on that and not create new business for yourself in other counties, okay?
Yes, sir.
Do you have a place to live?
Yes, sir. 262 Timothy Lane, Lilburn, Georgia. As a friend of mine, she let me stay there until I get a placement in behavioral health court, until they find me a place.
How do you plan on getting all the way from Lilburn to Hope Hall?
It's not far from the subway. train. It's not far. I live like about 8 minutes, 8 to 10 minutes from the train station.
Okay. Mr. Tucker, do you need any more information from Mr. Darden about his address?
No, sir. I think our investigators already confirmed it. We were going to get him out, so it's been verified already.
Great. Okay. And will Mr. Darden have an ankle monitor?
Yes, sir.
Okay. So Mr. Darden, when you get out, and I'm not promising you that this Douglas County thing's been cleared up, but when you get out, you'll come back to us. If you go to Douglas, you may just get out now. You will be fitted with an ankle monitor. That is a gentle reminder, not so subtle, that we lost track of you once before and we don't want you to disappear on us again, okay?
Yes, sir.
All right. Well, Judge Reeder will be the judge you're working with. It sounds like you never got a chance to meet her because you weren't in the program long enough. But she'll be working with you along with a real good staff at Hope Hall. And I hope that you take full advantage of what this program can do to help you work through the issues that I know you want to work through. You're not a young man anymore, and it would be great if we could help you break this cycle of ending up in Douglas and Rockdale and Fulton and Cobb and all that stuff, okay?
Yes, sir.
Do you have any questions?
Yes, sir. How would I let Douglas County know that I was incarcerated? I wasn't out to go to the court.
So Mr. Darden, we couldn't see where you were in. Where were you in? You weren't in Fulton.
No, I was in Cobb County.
Okay, you need to tell them that. When you need to tell them that, and they'll look it up and probably release you very soon. They'll release you, but make sure you tell your attorney there and tell them.
Okay, if there's no hold, if they already taken care of it, I'll get out.
Say again?
He asked if there is no hold on him from Douglas anymore, he'll get out.
Correct.
Do I
Which
need
it
to
seems
sign
that's what his booking sheet now shows. But when we researched it a couple of weeks ago and worked on trying to get him out, they were on there. And I don't know where hopefully they're gone for good, but you do have that Rockdale.
Mr. Darden in right now?
This, from his booking sheet that Miss Cheryl just sent me, this is the only thing holding him in.
So I'll get an order lifting the bench warrant or lifting something so that Mr. Darden can be released.
Correct.
Okay.
And if holds pop up, then we'll do what we mentioned earlier.
Okay.
And Your Honor, he also has a 16 SC 141700 sentence before Judge Brasher. Can we add that case to the BHTC program as well?
Yes, please. Let's do that. So, and Ms. Vortis is the perfect person to sort that out as Judge Brasher's litigation manager. Can you say the case again, just so we can all write it down?
Yes, Your Honor. He was sentenced on March 29th, 2016. The docket number is 16 SC 141700 of possession of cocaine, in which he was sentenced to 6 years probated.
So he has a couple years left on that?
That's correct, Your Honor.
Okay. So Mr. Darden, the wise suggestion from Officer Calhoun, who's with probation, is that we amend that sentence to include as a condition that you complete BHTC so that you've got all your Fulton cases under one roof and you're not having to report to probation on one while you're reporting to BHTC on the other, okay?
Yes, sir.
So I'll sign whatever I need to sign, and it may be that it's presented to Judge Reeder, but one of us will sign all those different things and we'll get you on your way, okay?
Yes, sir.
Thank you. Thank you.
Take care, sir. Thank you, Judge.
You're welcome. Mr. Forte, are you ready to pivot back to Mr. Baylor? He is. All right, Mr. Franklin, did you and Mr. Baylor have enough time to discuss what you needed to discuss?
Yes, sir.
Okay. And Mr. Baylor, are you electing to go forward with the sentence that I described, or do you want to withdraw your guilty plea?
I'll go forward, sir.
Okay. Well, I need to ask you a couple more questions. This is your indictment right here. You don't need to read it, but I've got it here. It's the original. Do you authorize me, Mr. Baylor, to sign your name? If you were here, you would have signed your indictment, but it needs a signature. Do you authorize me to sign on your behalf?
Yes, sir.
Mr. Franklin, do you authorize me to do the same?
Yes, sir.
And same question, Ms. Hall.
Yes, Your Honor.
Okay, I covered that. Mr. Baylor, I will repeat. If Mr. Franklin is able to get documentation from Maryland showing that your 05 case was a misdemeanor, then this sentence will become a first offender sentence. I need to tell you a little bit about first offender. It is primarily an opportunity for you that you've earned because you don't have a felony, if that's what Maryland tells us. And it means that this is not a guilty finding. You don't have a conviction. So even while you are on probation, if you're looking for work or someone's asking you, the answer is you are not a convicted felon. You understand that?
Yes, sir.
And if you successfully complete your sentence, then the thing is wiped clean and you can take steps to have it cleared off your record. But importantly, it is not a conviction. It is not an adjudication of guilt. Now, you can't have a gun while you're under this sentence. That doesn't seem to be your issue anyway, but you are not a felon while you're under the sentence. Do you understand that?
Yes, sir.
That's the benefit. There's a risk, as with all good things in life. If you, while you are under sentence, have another incident, you get arrested and you are charged and you get indicted, I could revoke not just your probation, but I could revoke your first offender status. And if I did that, I would have the ability to resentence you as a convicted felon up to the maximum in your case, which would be 45 years. I'm not saying that's what I would do. You'd have to do something pretty crazy to be resentenced for up to 45 years, but you need to understand the worst of the worst. So I'll give you a what if. If you are back in front of me in 3 years and you shot someone, I could see myself revoking all 45 years. It's that easy, and I would have the ability to do that. I don't want you to walk every day scared that there's 45 years hanging over your head. Different scenario. Let's say you get caught with methamphetamine in 2 years. You would not get revoked for 45 years, but your first offender status would probably go away. We'd probably try to get you into drug court or BHTC court or something like that, or some kind of treatment, maybe a Hope House scenario in that situation, but you'd lose your first offender status and I would resentence you and I could include prison time in there because you've already pled guilty. Do you understand that?
Yes, sir.
Understanding the benefit of first offender, as well as the potential risk of first offender, do you want me, Mr. Baylor, to amend your sentence to first offender status if Mr. Franklin is able to provide documentation that your 05 conviction from Maryland is a misdemeanor?
Yes, sir.
Well, I will do just that if I'm presented with that paperwork, and obviously Ms. Hall will get it as well. And if she's got a concern about it, she can raise that concern. We will do all that outside your presence, unless there needs to be some kind of evidentiary hearing. We'll take care of it automatically.
How will I know if that happened?
It would happen as soon as Mr. Franklin can get the paperwork. If he gets it to me and it's up to snuff, I'll get an amended sentence out the next day.
Okay, but how would I be informed? That's what I was asking.
I could put it in the mail to you. I could put it in the mail to him, and I'm also working on it right now. I know some people who used to work in the Baltimore office, so I'm playing a text game with some people right now, trying to get in touch with someone.
So it may be before you leave Rice Street, and then we'll get it to you there. But you are findable, and Mr. Franklin's office would mail you the amended disposition if that's how it plays out, okay?
Yes, sir.
All right. I think the last thing we need to do is I need to make sure you get the address for probation, because you will have 72 hours to report to probation upon your release. Whenever you're released, you do the full 2 years, you get paroled early, you'll have 72 hours to show up at the probation main office here in Fulton County to say, here I am, Mr. Baylor, here's where I plan on living. I need to know who my officer is, okay?
Okay.
Officer Calhoun is going to tell you that address, and my hope is that there is a sheriff's deputy there who's going to write it down for you to give it to you on a piece of paper, okay?
All right, he's getting something right now.
Great.
May I ask Ms. Roberts if she has a case number for Mr. Baylor?
Ms. Roberts, do you have a case out of Maryland?
Yes. You said a case number?
Yes, ma'am. Do you have that?
Give me 1 second.
And if not, I have it.
Go ahead with the address.
All right, let's do the address first. Officer Calhoun. You're muted, Officer Calhoun.
Taylor, I'm Officer Calhoun with the Department of Community Supervision. We're requesting for you to report within 72 hours of your release from custody to 276 Memorial Drive. Failure to do so will result in a warrant being requested for your arrest. That's the Fulton County Probation Office.
Yes, sir.
All right, did the officer write that down for you, Mr. Baylor?
30303, right?
That's correct.
Yes, sir.
All right, gotcha.
Fantastic. Mr. Baylor, I wish you the best. I want to again commend you for how you've spent your time while you've been at Rice Street. I'm hoping that's a trajectory you will continue. I think it's a good sign that Mr. Mills wants to keep you in his life and vice versa. But if you can stay on the medical regimen that the doctors have for you, you demonstrated you can get good employment. You just got to stay sober and keep that job, okay?
Yes, sir. One quick question.
Mr. Franklin, you need to get that case number.
One quick question, just to make sure. So I'm serving 2 years, and how much time is on probation?
3 years probation, and then there's 5 years suspended after it. That's that one count that has to run consecutive.
Okay.
So it's 2 in, 3 probated, 5 suspended.
Yes, Your Honor. Thank you.
Okay. Case number?
I sent it in the chat. You want me to say it out loud?
Oh, no. As long as you send it to Mr. Franklin, that's great. Okay. All right. Thank you, everyone.
Thank you.
Thank you, Your Honor.